500 people in the room. And all right, and so I think that will be sufficient for this civil trial. We've talked in chambers about some procedural issues off the record with regards to various issues. The court has held hearings previously in the case, May, and then most recently on June 5th, with regards to various matters. I'm happy that it appears that all discovery issues have been complied with, and at least to the point that it was not necessary to supplement the motion for sanctions filed by the plaintiff. I think what I'll do now is simply have the parties recap their positions on the motion for sanctions, and then my hope would be to get a ruling on that out back to you very, very promptly. Want to make sure I've got Amber at loarpllc.com.
Yes, Your Honor.
And let's see, Mr. Stafford's right there. I think I've still got the other guy. Let's see, G. Stafford. Okay. My hope would be by the end of the day to just send y'all an email, copy the clerk to let you know what my ruling is going to be on that issue. Okay, so we do have Ms. Russell, Ms. Phillips here on behalf of the plaintiff, Mr. Stafford's here on behalf of the defendant. So take some time, Ms. Russell, and walk me back through what your request is.
Thank you. Good morning, Your Honor. Unfortunately, over the past year and a half, we have seen continued delays and non-compliance and the failure to produce critical evidence in this case. This has necessitated this is the 5th hearing, 5 hearings before this court. It has resulted in us taking 8 depositions without access to crucial information. We've had to retake 2 depositions, and in one of those depositions, the new information actually resulted in one of the witnesses changing critical key testimony about what he had alleged in his first deposition that he saw happen in the very incident that is the heart of this case. As the court knows, this case is about a young man who had no training and no experience and was brought out to help wrangle and castrate and vaccinate calves and put in a very dangerous situation where he ended up being bucked and hit in the mouth by a calf's head. He resulted in having over 50 dental procedures, including implants, root canals, crowns, caps, very painful. At the heart of that was a dispute over whether procedure was followed and enforced that day. I'll take you very quickly through the timeline. I'm happy at any point to stop and go back over specific dates. Your Honor, in this case, we were filing suit back in March of 2023. We served discovery, and defense's responses after we gave a voluntary extension was due in June of 2023. We followed up on discovery time and time again because they did not produce any videos or photos with respect to the relevant discovery questions. When we didn't continue to not get a discovery supplement, we sent another email. So that takes us from June all the way to October. We had multiple phone calls over the summer. We were promised we would get official supplements. We did not. In November of 2023, we sent our first meet and confer letter. It was only after that that defendants produced 3 GoPro videos from the scene of the incident that actually go again to the heart of the case, showing that procedure was not followed. We were given a blurry copy of the video that actually shows our client on top of the calf that injured him immediately after. That video to date has continued to only be a blurry version, and there has been no answer as to why a better version hasn't been produced. I will say, in preparing for trial and going back over initial disclosures, I was surprised to remember that in a statement given just months after this incident occurred, a recorded statement to her insurance. Miss Seal told her insurance that she had video that showed this. So it was in her possession unequivocally, and there's been no rationale as to why it wasn't preserved or provided. Continuing on, though, in the efforts that have gone forward to try to find out what evidence there is, even after we got the 3 GoPro videos and we got the blurry video, we still felt like there was missing evidence from testimony, from what we hadn't seen. We sent a second meet and confer regarding the missing videos in November of 2023, and then ultimately had to file a motion to compel. Only after we filed that did defense counsel send a letter that said, you've got everything we've got. And so we ended up coming to that hearing, that first hearing in January, and entering an agreed order. And in that order, this court required defendants to produce all responsive documents on those photos and video requests for production 8 and 9. Assuming that at that point that we had been given everything as it had said in their letter, we designated our expert. We noticed the next depositions, and we took a round of 8 depositions without the benefit of that information. In that round of depositions, 2 fact witnesses confirmed that in fact there was a conglomerate of photos and videos that they had given to the SEALs much earlier that had not been produced to us. That led to us filing our motion for sanctions in April of 2024. We followed up again in writing asking for the information. We followed up again with phone calls. And then only on April 15th, 81 days after the court's order and 3 weeks after the depositions, did defendants finally produce additional photos and videos that show right before the incident, show the injuries. And yet we still were able to look through that and identify another missing video. We had to present our expert at that point for deposition. We had our first motion for sanctions hearing in May 2024, so we're now a year out. We were then sent additional links to photos and videos after that. Those links and videos didn't work, but the link was then corrected the night before the next hearing, which was May 14th. That was our second hearing when the court ordered that an additional affidavit needed to be provided to explain why the blurry video hadn't been given, ordered that we would be able to redo 2 depositions, and then rescheduled us for another hearing, reset our trial date. Because again, it's important to remember all of this was happening when we were just weeks away from our first trial setting. May 28th, we got an updated affidavit, and we learned now of 2 new witnesses that had never been disclosed in initial disclosures. We then had a third hearing on the motion for sanctions, an updated affidavit, and we were able to, as I noted in my summary, retake 2 of those depositions and have critical key testimony change. Although we are not hearing the motion for summary judgment today because it's been withdrawn by defendants, I do think that it's important to note that yet again, when we're on the eve of trial, we're seeing that pretrial preparations are being interfered with. The defendants filed a baseless MSJ with no excuse for it being 6 months late past the court's deadline for filing that motion. And it was based on incorrect law and omitted controlling Supreme Court case law. The relevancy being that, again, plaintiffs had to stop preparing their case in order to respond to that, which incurred additional time and expense. We have submitted all of our attorney's fees and expenses that were made necessary as a result of this continued delay and denial of evidence. And so with that, Your Honor, we request that the court grant our motion for sanctions. At this point, we are focusing on the submission of our fees and expenses. That includes all the work up to the last submission. It doesn't include any time for today. And at the end of all of this, the basic premise is that the Texas Supreme Court emphasizes that discovery is to facilitate trials based on truth, on information that is given and known, not on concealed facts. And unfortunately, in this case, we've seen that sanctions are necessary to show defendants that they have to comply not only with the rules, but court-specific orders. Your Honor, I'm here for any questions that the court may have.
So you have your submission on plaintiff's attorney's fees and costs that was filed on June 18th. That's besides your summary, your most recent document, correct?
Yes, Your Honor.
All right. And so subsequent to that, you filed your summary, and that's it. All right. So Mr. Stafford, do you want to respond?
Yes, Your Honor. Thank you very much. Uh, as the court also allowed, we filed our response to their attorney's fees request, and it is in the court's records. I'm trying to pull up the exact that we filed it. It was June 25th as the court requested. At that point in time, just to summarize things, Ms. Russell used the phrase again today, critical evidence. If the court may recall, on the June 5th hearing, no, not the June 5th, the May 14th hearing, we were advised that there were two additional witnesses they wanted to redepose. Before we left the courtroom that day, we actually worked out dates and confirmed those to be redeposed, and they were done on May the 29th. A total of 3 hours time taking those two depositions. And on their submission, it's like on their submission for fees, it includes like $456 worth of court reporting charges. That's the day I left my briefcase in the court, matter of fact. But that being said, our position has not changed. At the hearing we had on that date, June the 5th, I believe, they showed a blow-up photograph of one of those photographs that was critical evidence in this case. And they had a huge blow-up of it for the court to see. And I showed the court at that time the prior picture of Mr. Rebicek's tooth also. The only difference was he had his head turned 20 degrees differently. As counsel appropriately said, 3 GoPro videos were produced. Our expert reviewed those GoPro videos before his deposition, as no depots were taken until this year in this case, by the way, Your Honor. And he reviewed those GoPro videos, which were like 17 minutes long. I can't possibly figure out how many. If a picture's worth 1,000 words, a video's worth thousands of pictures. They're complaining about 40 photographs and short video clips. We gave 7 of several seconds duration each. We gave 17 minutes of GoPro videos. We're not trying to hide anything. Ms. Seeley testified she lost her phone that had this information on it. The 2 witnesses redeposed said they had sent to her information. Unfortunately, though, it was not on her phone. She would have given it to us because otherwise she gave us the GoPro videos. Why not give us everything, Your Honor? And again, those are minor compared to the 17 minutes of GoPro video, which shows duplicative in greater detail and more voluminous of what was on those shorter ones they're complaining about, Your Honor. One of the 2 witnesses said he only sent a few photographs and he attached his text message with Sherry asking him, do you have pictures of when the boy got hurt? And he said, I did not. The other witness said, yeah, I was wrong. It's the wrong calf. I can't blame the plaintiff anymore. Fine. I got that. That was the big change we had. So this critical evidence, Your Honor, was duplicative of what had been produced in many, 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 many times more by the 3 GoPro videos.
Okay, let me interrupt before I forget.
Certainly.
You just said something about the wrong calf. Tell me that again.
Yes, Your Honor. One of the 2 witnesses that Ms. Russell or Ms. Phillips redeposed had, in his first deposition, said that the plaintiff dove in wrong to grab the calf. And we found a picture in the subsequent production that showed apparently the calf that Mr. Rebicek was injured by. And he recanted his statement and said, no, I don't blame him anymore because that's a different calf, it looks like, than what I remembered seeing. But I don't recall, in great detail. So that witness did state that, Your Honor. And those are photographs that were on his phone or the other part-time employee, Ty Fitzpatrick's phone, which they had. And the way they gather those information, by the way, Your Honor, is after the roundup, people go to the local restaurant, start airdropping stuff. And these 2 cowboys don't know a whole lot about airdropping, but they got a conglomeration, as he called it, and Ms. Russell pointed out, of videos and photographs that just bombed into their phone going back for 20 years on his phone. He just has that stuff. Because he's the foreman, he's been doing it forever. He thinks it's fun. He enjoys himself. That doesn't mean Sherry had that information available. And with regard to this blurry video, I've got, if I need to show it to the court, the testimony of the plaintiff's mother, who said that same blurry video she got off of Dalton's phone, the plaintiff, but he lost his phone. And I said, well, I can't blame him for losing his phone because my client did the same thing. So the very blurry video, which starts with Mr. Rebicek on the ground and a witness on top of him, on top of the calf, was in Dalton's possession as well. At some point in time, but he lost his phone. So I'm not certain, it's understandable. People lose their phones, I guess. I've lost one. But each side's lost a phone, and we're being attacked for that, which is what had these photos and videos that Miss Seal was given by these other 2 part-time cowboys. So when you look at it, it's the crucial and critical evidence of 44 photographs is greatly subsumed within the 3 or by the 3 GoPro videos for 17 minutes long. The big photograph difference was a 20 degree turn of his head. The witness did change his story, Your Honor. That said he didn't blame Mr. Rebicek after seeing that one video. Her expert was deposed, and so we've got a bunch of part-time cowboys gathering information, Your Honor. When it comes to the amount of fees and the hourly rate, our response addresses, as does theirs, the amount of those fees and what we believe in that regard. But the two videos that were redone were 3 hours long combined by Zoom, and they've attached $400 some odd worth of expenses for the court reporter for those two depositions, Your Honor. I don't believe that draconian sanctions of that type of money being sought, $45,000 from Miss Seeley. That's only against Miss Seeley, Sherry Seeley, because she was the one that the Cowboys said they'd send her stuff to, but she lost that phone. And she does not know why the blurry video is, where it is. She's asked her granddaughters, it says in the affidavit. She's asked other people, and no one has it. Dalton doesn't have it anymore. No one can find the better version to clear it up, but she didn't do anything to alter that video one bit, you know. So I just think that, Judge, the request for $45,000 attorney's fees for 40 photographs or snippets of videos pales in comparison to what we did produce. We didn't withhold things intentionally from them in that regard with those 40 photographs, because we gave them the videos, the GoPro videos showing the activities nonstop. One video is 15 minutes long. You get a good feel of what's going on. The jury will know it. We wouldn't have hidden photographs when we're producing GoPro videos, Judge. So I don't see anything which is intentional or horrible.
Perhaps. I don't know. I think that's, as I probably said the last time, that perhaps is true. All right. Do you want to respond, Ms. Russell?
Thank you, Your Honor. Very briefly, I'll hit a few points. First, you can't say I gave you 3 videos and I omitted 4. You don't get to cherry pick. And that is absolutely a violation of the way our rules work. Second, it's not just a what if there was a really important video in there. It's actually, to Mr. Stafford's point, the only witness that said in the first round of depots that he witnessed what happened and blamed Dalton recanted his testimony only after we got that. It took multiple motions and hearings and phone calls and emails to beg to get the relevant information, and it absolutely made a difference. They recanted their story. It was critical. It was not about a photo that we brought to the court to show the court a demonstrative of his injuries. It was about a critical photo that changes the only witness who said he saw Dalton do something wrong when he got hit. That was recanted. And Your Honor, the witnesses that Mr. Stafford refers to, all these people that had it on their phone, it really comes down to 2 witnesses that are employees of the SEALs, and there are text messages that we've raised both in our plaintiff supplemental motion for sanctions on page 7 and throughout our motion history that show that Ms. Seal was corresponding with them in January of 2024. This is in smack dab in the middle of us filing motion to compel, motion for sanctions, and it is after the court has issued orders that she produce everything. And yet these weren't sent over to us for months, despite proof that they were sent to her in January of 2024. That's not about losing your phone. Sitting on evidence is the same thing as withholding it. Regarding our attorney fees and rates, if Your Honor has any questions about those, I can divide it into 2 categories. There's the category of delay. It takes a lot longer to do a deposition when you don't have all of the evidence and you're having to fight a witness that's telling you wrong information. So we have about half of our fees and expenses on that initial having to do depots blind, having to do the initial motion to compel. And then we have a separate section, which is half of it, which is 5 hearings, motion for sanctions, and having to redo multiple depositions. Our rate has not only been proven fair and reasonable in our motion itself, we've attached an order from June of 2024 where another court has approved the rate for both myself and Ms. Phillips as reasonable and regular. That is the rate I charged over a decade ago, has not gone up. That has been a very consistent rate. Ms. Phillips still does hourly work at our firm. She has charged that out on multiple cases over the last year. So they're very reasonable and regular. And any questions on our expenses or our fees, we are prepared to answer, Your Honor.
All right. So your bottom line total request, ma'am, is at the 44,977.20?
Yes, Your Honor. And if the court were to find that some of that should be from defense counsel, we focused it on Ms. Seal, but we're amenable to however the court thinks it should be divided.
Anything else, Mr. Stafford?
I would just refer the court to the response with our position on the attorney's fees and employment law cases where they were found reasonable charges. Mr. Adamy and I have been doing this for 40 years apiece, and our rates are less than $200. As far as cherry picking, it's only cherry picking when you have all the cherries in your possession. These part-time cowboys' personal phones were not my clients.
All right, thank you. We'll go ahead and recess from the record. And as I said, I'll do my best to get a decision out for you promptly. You can check your email and maybe over the weekend. And I'll see you in Junction on December 4th at 10 o'clock a.m.
Thank you, Your Honor.
Thank you, Your Honor.
All right, we'll recess. Thank you.